What is a contested probate? Welcome to Frank Bruno Law. I am Frank Bruno. Sometimes I go forward, sometimes I go back. I've been discussing probate, so I think it's only fair to discuss a contested probate. So sometimes an heir, a beneficiary, the executor or proposed executor will come into conflict. There's a series of, there are different reasons for why there might be conflict. I'm only going to speak about the will contest in this video. So what is a will contest? And what is a contested probate? Well, contested probate is when there's the conflict, just very generally. And then a will contest is a specific type of conflict within the probate proceeding. That's when someone challenges the purported will. So the executor, proposed executor, has to bring forth the will to the surrogates court in New York to determine the validity of the will. And someone from the outside says that will is not a legitimate document based on one of a few theories. The will was a forgery, just a fake will, or the signature was a forgery. The will was a fraudulent document. That's another one. Testamentary capacity. So this is where there's an allegation that at the time the will was signed, the testator, the maker of the will, the person in question, did not have the legal capacity, the mental acuity to sign the will. So that, in a nutshell, is a will contest. Now, should the person that alleges the will is not valid, should they win and no other will is brought forth, right? Hey, that's a fraudulent document, it's a forged document, here's the original will, right? That would be a scenario. But if there is no will and, no other will, and the proposed will gets thrown out, well, then there's no will to probate, and the matter must proceed in an intestate fashion, meaning no will, and the assets of the decedent will be distributed pursuant to the laws of intestacy. So if you have a will that you want to put forth to be probated, reach out to me. If a will has been submitted for probate and you think there was a problem with the will, a fraudulent document, a forgery, you think that at the time the will was created and signed, executed, that there was an issue with the decedent, well, it would have been the testator at that time. But if you think there was an issue of testamentary capacity, reach out to me. Who distributes assets after a probate? In the process of probate, the executor of the will, right, I've gone through all the steps. The executor of the will takes the will to court, files the necessary petition, supplies the necessary original documents, ultimately obtaining letters testamentary. And then who distributes the assets of the decedent? Who distributes the assets of the estate? Well, it's the responsibility of the executor. If the decedent had assets that were, largely in cash or mutual funds or things of that nature, right? The distribution may be as simple as writing a few checks. If the decedent had property or multiple properties, well, then it would be the obligation of the executor to, say there's a property. It would be the obligation of the executor to distribute that property to the heirs. So say there's 5 heirs, the executor could make a deed to the 5 heirs, 20% each, depending on the terms of the will. That is definitely a possibility. A different option may be that the executor could sell that property for the highest market value and then attend the closing, take care of any issues related to closing the property, and then take the proceeds of the sale and distribute that to the heirs. So it is up to the executor to distribute the assets. How do you initiate a probate proceeding? It starts with filing a petition in the surrogate's court along with the original will, a death certificate, a paid funeral bill, and a petition. It's an application that the will be admitted to probate. Now, probate is the process to prove, validate the will, and to appoint an executor. So the person that typically will file this is the proposed executor named in the will. If there's no executor named, then really it would be the spouse of the deceased person or an adult child. It could also be a relative. In fact, it can be any interested person. So a beneficiary in the will, a relative, a creditor, so someone that is owed money by the estate could start. We'll see that sometimes with, like, say, a bank that's looking to foreclose on a mortgage or a reverse mortgage lender. Sometimes they'll start a petition in surrogate's court seeking permission to sue the estate to recover, right? Sometimes a person has a reverse mortgage. They've been living in the home, they're alone, then they pass away. Now the bank is owed money, and there may not be a relative that will step forward to take care of the estate. So sometimes a creditor will file. So that's how you initiate. It starts with going to the surrogate's court in New York with a petition and the related documents. What is the purpose of probate, and what are some of the important functions of probate? The last several days, I've been doing a dive into probate, and I'm up to the last 2 functions of probate that I want to discuss in this series. So the estate representative, the executor of the estate, has to deal with heirs, potential inheritors, so has to resolve disputes, potential disputes between inheritors, right? Siblings might have a dispute between them, or between the estate and a potential inheritor. That might be an issue. Or between the estate and a creditor, possible creditor. So the probate process is designed, the function of it is to have the executor deal on behalf of the estate with these outside forces, the potential inheritors, either among themselves, or a potential inheritor against the estate, or a creditor against the estate. And once all disputes and creditors are paid, and the executor has determined who the beneficiaries are in the will, the heirs in the will, then the executor has to distribute. So I've gone through a series of tasks that the executor is assigned to, was obligated to take care of, ultimately resulting in distributing property, money to the beneficiaries named in the will. So speaking to someone today, and they said, I was on your website and I looked, do you do elder law, you do estate planning, you do guardianship, do you specialize? So I said, yes, that's what I specialize in, areas for the seniors. So in any event, I'm continuing along with my series on probate, and yesterday I discussed initiating the probate process, right? Filing the original will, petition death certificate with the court. Okay, now, what happens next? Well, there's a notification period. The person that filed, in New York, we call that the executor. It's a similar process if there's no will. The administrator is required, so the executor is required to provide notification to persons in the will, to interested persons, to creditors. And really what this is it's a mailing of the will, and along with a waiver of process, meaning that the person that receives the notification of the surrogate's court process can sign a document saying, I'm not going to contest or challenge the will. So that's really what has to happen. Notification, it allows, and it should be mailed to this person. If you don't know where a person resides, maybe you have an awareness of a person and their name, you would need permission to publish in the newspaper notification about this process. It's all about giving someone time to either receive the asset that they may be entitled to, right? The bequest, the inheritance, right, for the potential inheritor. And also it provides creditors with a time period within which to make a claim for the amount that they're saying may be due as a creditor. Gathering assets and filing an inventory with the court. So when you're in the probate process and a will is provided to the court, ultimately there are letters testamentary that are issued by the court. Oh boy, I'm so choked up. Letters testamentary are issued to the executor, and then the executor must locate assets and file an inventory with the court. Stocks, bonds, bank accounts, mutual funds, artwork, collections, could be personal property, right? Once you find those assets, it could involve some detective work. You might have to capture the mail, see what financial institutions are, in correspondence with the home, statements of account, maybe check digital records, check the tax returns from the year before, prior years. This would be a great time to capture the mail, catch 1099s and W-2s. Right, each institution has to give you a 1099 for interest that goes to the account. Once you marshal the assets, you file an inventory. And that's it for this stage. Probate process, what happens after you file the will? You file the death certificate. You file a paid funeral bill. Well, the request, the application of the court to the court is to appoint an executor, right? So that's really what that initial stage of in the probate court is attempting to do. Why? Well, when a person has passed away, if they have any assets in their name, individually in their name, there's no joint tenancy, there's no beneficiary designation, right? In my example, a person has an asset in their name and then they pass away. Well, that asset is frozen in the name of the deceased person. And what you need to do is make this application in the surrogate's court in New York to obtain letters testamentary. Letters testamentary. That allows the executor, some states call it a personal representative, but it allows the executor to open up a bank account, to marshal assets, to address creditor claims, to pay creditors, and to distribute assets to the beneficiaries of the will. So that's the process. That's what we're looking for when we do the probate. Now, there could be a process where someone is going to challenge the will, challenge aspects of the will, or challenge the fact that they don't want you to be the executor. I've sidestepped that for the purposes of today's conversation. And in our example, things went smoothly, and the court issued letters testamentary. What is probate designed to accomplish? The functions of probate. Before I get to that, if you would like to make an appointment, please go to frankbrunolaw.com. You can speak directly with me. Get on my schedule, and we'll have a conversation. So, probate allows the estate, right, the executor, on behalf of the estate, it allows the estate to enforce the rights to money and property that the decedent was entitled to. So that's a function of probate. Also, it allows the estate to handle any business affairs. Say the decedent had owned a business, a franchise, a small business, a plumbing company, any type of business, any type of corporate entity. The executor can act on behalf of the estate to go in, take an inventory, take an accounting, find that information about the estate, about that business for the benefit of the estate. And then the final function for today is taking care of taxes, right? If there are any taxes to be paid, city or state, or even estate taxes, that's a function of probate. So, 3 today, right? In and out. If you would like to speak with me, if you want to discuss your situation, please reach out to me, frankbrunolaw.com. Thank you.